What you know, Alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Sunday, December 7th. I wanted to take some time this evening to knock out some of these filings in the Kouri Richins case. It's really hard when I'm covering a trial to do anything else, but closely following Kouri Richins, she'll be going to trial in February, and there's a good chance I will be out there for some of that. I've never been to Utah, but I have some very dear friends that live out there, so hopefully that happens. Sky Lazaro was originally Kouri's attorney, but she withdrew due to a conflict of interest. Next in line was Wendy Lewis, Kathy Nestor, and Alexander Ramos. They took over in May of 2024. There was a ruling on November 20th regarding the state's motion for an order to show cause. This is regarding a filing by the state saying that Kouri's attorneys are in contempt of court for violating the protection order with certain statements that they made during an interview with KUTV News. Now, before we get to the ruling, I watched the interview and made some notes on the most important parts they talked about. So let's go over that first. First up was a coworker of Kouri's from Home Depot, which is where she met Eric. She said, "You would never forget Eric's laugh." She encouraged Eric to talk to Kouri after Kouri caught his eye. And after the first date, they were glued to each other, and she said it was perfect. Moving on to the interview, all three attorneys were on there, and they were the ones who called the station and requested the interview. Kathy Nestor said that they did the interview to address serious areas that have been discussed publicly in open court, and says the prosecution has declined to correct false information that has come out in the media. Investigative reporter Wendy Holleran asked Kathy Nestor if her client is the Moscow Mule murderer. And she says they don't know the prosecution's theory regarding a murder weapon because they've never told the defense their theory. They never said the fentanyl was given in that drink. She said she asked the lead detective during the preliminary hearing, "Do you know how she administered the fentanyl to Eric?" And he said no. And the prosecution has never said that was how it was given to him. She says that came from a statement Kouri made early on that they had that drink before he died. And she says sitting here today, she can't say how the prosecution is going to say Eric ingested the fentanyl because they've never said that in court or in any filings. She said they believe Kouri is innocent and she wants what's out there to be accurate. Now, Kathy Nestor went on to talk about Kouri's financials and Kouri owing hard money lenders $1.8 million and just being in huge debt. She said the public failed to take into consideration the huge piece of property she obtained, and she's referring to this unfinished mansion that she bought 2 days after Eric died. Now, remember, Eric did not want Kouri to purchase this property. She said the equity in that house alone and the value of it was enough to cover any debt Kouri had in her business, and they feel that's been improperly reported and it's very misleading. All the reporting is about debt service and not the values of the properties that Kouri had. Wendy Lewis talked about the life insurance policy, saying it's been reported that Kouri took out hundreds of thousands of dollars in life insurance policies on Eric before he died. She says that's not true. Kouri took out one policy that came in the mail. She said it's the one we all get from our credit union saying sign here for $100,000 in free life insurance and sign here for your spouse. And that was sent in about a month before Eric died. The other policies were taken out by Eric long before he passed away. She said the extra $100,000 would be a lot for a lot of people, but for this family, it was not really all that much. When asked if the prosecution had an ethical obligation to correct these things that are in the narrative, she said if they want justice to be served, they have an obligation to do that. One thing that's been reported that the state has not corrected is that Kouri Googled, how much fentanyl does it take to kill someone? She said that's been in the press and exploited, saying that she did that before Eric's death, but that's not the case. We discovered through court records and exhibits, she Googled that a day or two after Eric's death, after she was told he died of a fentanyl overdose, not before, which she says makes perfect sense. Kouri does not know how Eric died. That's a very different narrative than to leave out there, oh, the Moscow murderer Googled how much fentanyl does it take to kill someone. She says, no, that's not what happened. She's asked if she feels the language the prosecution uses in its filings has crossed the line, and she says yes. This has been interesting. She hasn't seen the language in filings like they're seeing in this case. The prosecution has a very strong opinion on this case, not just here's the evidence. They seem to have a personal opinion, which I think is reflected in their pleadings. Our job is to protect our client's rights and make sure she gets a fair trial. Their job is to serve justice. What they think is justice and what we think is justice is very often the opposite. And it begins to get personal sometimes, and she says this has become quite personal for the prosecution. When Ramos was asked if he thought the prosecution is injecting a false narrative to the media, he says, I don't know that they're necessarily injecting it, but they're not correcting it. And he says that's why we are interviewing today. With a client facing serious charges and the misinformation out there, it's not being corrected. It's a disservice to justice. He thinks the public is just adopting the narrative because it's the prosecution. It's the state of Utah. This is a high-profile case, and he thinks people need to be more critical because if what's going on in this case goes on to a lesser degree in other cases that don't get the exposure or the appropriate resources, that's when it starts to become a danger. Their job is to stick to the facts, and that's something they haven't done in this case with how it's been portrayed in the media. If their goal is justice, they have not lived up to it, at least in this case. When asked why they reached out to 2 News Investigates, Kathy Nestor said, we have a lot of confidence in you and we're hoping you can get the word out. It's kind of the one pebble in a pond. Once you throw the pebble in, the waves spread out. We hope once we correct it in a place that's credible, that's a well-known news source, then maybe other news sources will also start to question a little more about what they're hearing and what they're covering. Ramos says when you hear these false narratives and you know what you believe to be the truth, it's frustrating. When you're doing your job and upholding the Constitution, that's a high bar. And we see these narratives come out, then it becomes a game. We forget there's someone on the end of that, and that's a client, a human, a mother, and it does frustrate me. Wendy was asked if Kouri was aware of these narratives and how does she handle what you claim is misinformation being spread about her. She said Kouri is distraught and heartbroken. This has been very difficult for her. She's been in jail for over 2 years, and she hasn't had the opportunity to tell her story until trial, so it's been very difficult on her. Now, the prosecution was asked for an on-camera interview by the news station, and they responded, we're aware of the recent filings submitted by the defense. We will address all matters related to this case through the legal process rather than in the media. Our formal response will be part of the public record next week. We ask this comment be included in your report to ensure our position is accurately represented and the reporting remains balanced. So moving on to the ruling, Judge Mrazek ruled on that motion for an order to show cause. It says there's a protection order in place which states in part lawyers who have participated, are now participating, or will participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Among other provisions, Rule 3.6 prohibits a lawyer from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially causing prejudice and adjudicative proceeding in the matter. The state requested a ruling that Kouri's attorneys are in contempt of the court's authority for violating the protection order with certain statements they made during the interview. They also requested barring defense counsel from making any further extrajudicial statements in connection with this matter without a neutral's prior approval. The state asserts defendant's counsel violated the protection order, which incorporates Rule 3.6 of the Utah Rules of Professional Conduct by participating in an interview with KUTV News to, quote, influence future sworn jurors because counsel believes the playing field in the courtroom is not level. In response, counsel asserts they complied with the safe harbor provisions of Rule 3.6 and their public statements were necessary to respond to numerous false narratives that threatened to deprive Kouri of a fair and impartial veneer and jury, which the state has allowed to percolate without correction. What is the safe harbor provisions? I looked it up, and it provides exemptions or safe harbors for lawyers' extrajudicial statements, allowing commentary on general claims/defenses, public record information, ongoing investigations with limits, but prohibits statements likely to create a substantial risk of material prejudice, like opinions on guilt, credibility, or evidence inadmissible in court, with specific criminal case allowances like the accused identity and arrest details. The key is balancing free speech with fair trial rights, focusing on what's necessary for investigation/defense versus what could prejudice the proceeding. So back to the ruling. The court expresses no opinion one way or the other regarding the substance of the parties' positions. Rather, the court merely recites their positions to highlight the nature of the evidentiary hearing that would be required to resolve their conflict. To prove contempt, the state must show the defendant's counsel intentionally failed or refused to comply with Rule 3.6 as incorporated into the protection order. Given the parties' competing positions regarding whether defendant's counsel's interview falls within the safe harbor provisions of Rule 3.6, such a hearing would require a detailed discussion of and detailed findings regarding the substance and timing of extrajudicial statements by several actors, as well as whether those statements are consistent with admissible evidence on the record. Such a hearing would be a distracting sideshow that would siphon the parties' resources away from preparing to try the merits of this case based on admissible evidence. Moreover, such a hearing would be counterproductive because it would re-elevate the media profile of inadmissible evidence and speculation during the period immediately before jury selection. In a footnote, he refers to a ruling where he denied the change of venue motion because of the extreme media attention on the case. That ruling says, compared to previous cases in Summit County, the extent of media attention to this case has been extreme. The nature of that coverage has been adverse to the defendant because it has been incomplete and misleading, involving inaccurate summaries of evidence that may be admissible, discussion of evidence that the court has ruled is not admissible, and speculation by commentators who have no personal knowledge of the facts. The nature and extent of the coverage of this case as compared to the relative paucity of coverage of other criminal and civil cases is an indictment of the involved media outlets and our current media culture. Nonetheless, the media coverage of this case has not been omnipresent. Rather, it has involved significant periods of media inactivity between court hearings and significant filings. He goes on to say that holding an evidentiary hearing on the state's motion to show cause prior to trial is not in the interest of justice. In so ruling, the court does not, and not is underlined, minimize the importance of compliance with the court's protection order, which incorporates Rule 3.6 of the Utah Rules of Professional Conduct. Counsel that fails to abide by the order may be held in contempt and sanctioned. So that was denied without prejudice, meaning that can be revisited again if need be. If the state determines it's in the interest of justice to do so, the motion may be refiled following trial. So that was it for that ruling, but I will link that interview in the description below if you guys would like to go watch the whole thing. But that is it for this episode. Hope you guys have a good rest of your evening, and we will see you soon.